Okay, today we are going to discuss the defense now. Yeah, the focus is on the defense and how to defense with those three items. We remember before that if you are breaching, you are doing something violating the contract, the claimant will be able to claim for compensation, right? We talked about last week too, cost, expenses or cost, and then losses and interest, right? Biaya, rugi, bunga. Those are the three components that we discussed. And those three we can claim if there is a breach of contract, yeah? So you should differentiate between these three components that can be claimed based on the breach of contract and the components that you can claim or we can claim if there is an unlawful act. Yeah, it's a different components. Under the contract law, the components to be claimed are limited actually, yeah. But under the unlawful act, actually you can claim anything, you can claim any amount, yeah, without any limit. So this is different. If you are entering into a contract, the parties already are aware that under a contract, what I can claim against the other party is limited. Yeah, it is not unlimited. Yeah, you cannot just claim any amount that you like when you are bound under the contract. Yeah, so that's why we learned last week that it has to be expected from the beginning what one will suffer if the other party breaches the contract, for example. It has to be a direct consequence. It cannot be indirect consequence. Yeah, so it has to be proven that because you do this, then I suffer this. Yeah, because you do this, then I suffer losses in this amount. Yeah, everything must be proven. So we cannot just this is my losses, but if I cannot prove it, then it means nothing. Okay, those are the things about the claims, and now we are talking about the defense now. The claiming is the offense, right? There is a party offending the other party. It's an offense strategy. Now how to defend yourself? Okay, the first item is, I think, the easiest and the most common, yeah. The easiest and the most common, I think, is a force majeure. Yeah, it's a force majeure. Well, it's not easy to prove, but if you can prove that there is a force majeure, you will your obligation to pay for compensation is going to be waived. Yeah, under the law. The three components that we talked about before, the cost, losses, and interest, will be removed. Yeah, because there is a force majeure. And the number two is the claiming that the creditor has also been defaulted in his obligation. Claiming that the creditor has also been defaulted in his obligation. Okay, this one is not easy. Yeah, it's not very easy. It's not very common. Maybe, I don't know. Maybe it's quite common, but it's not easy to prove. Yeah, and even though it is proven, it doesn't mean that you will win the case, yeah, or your defense will be admitted fully by the judges, yeah, because sometimes in a legal case there are so many factors, there are so many problems, yeah, arising from the default, and this is only one strategy to counter the claim, yeah, but it doesn't work all the time. So this strategy says that if you are claimed because you are considered as violating the contract, yeah, but in fact the other party, the claiming party, was also defaulted in his obligation, then you can say that you cannot say that I'm violating the contract since you yourself did a violation of the contract. Okay, kamu duluan yang melanggar kontrak gitu. Yeah. So we will discuss this in detail. Number 3 is claiming that the creditor has waived his right to claim for compensation. Now, this is even harder, right? Harder to prove. And if you later learn about contract drafting, and when you read so many agreements, you can see that there will be a clause in the contract saying that no waiver clause, yeah, meaning that any waiver under this agreement of any right or of obligation of any right, see, it should be referring to the rights, should be cannot be considered having been given, yeah, unless it is made in writing. So the point is, there will be no waiver unless it is given in writing. So why there is a provision like that in the agreement? Because of this third point, actually, yeah. Because you might be considered as releasing your right to claim, yeah. If you are silent, if you don't complain about it, yeah. If you maybe you object before, yes, about something, but then you keep your mouth shut, yeah, you don't fuss anymore about it, then you might be considered as releasing your right to claim. Well, this is not easy, right? This is not easy. This is case by case, but that might happen. Yeah, that might happen. I think I also had a recent case about it. I don't really remember, but it can happen anywhere, actually. Yeah, I remember a case. I remember one case. Yes, and this is about this third item, actually. So there is a claim by the investment manager. This is a capital market transaction. Yeah? So the customer instructed something to buy shares through this investment manager, the broker, yeah, the stock broker, and then the stock broker bought those shares, yeah, and then ask the company, the customer, to repay the money to them, but it hasn't been repaid, yeah. But what is interesting in that case, and what is weird also, and not supposed to happen actually in the normal circumstance, is that the party doing the instruction to purchase the shares was the shareholder of the company, of the customer, yeah, the shareholder. So the shareholder controls the company, giving instruction, buy and sell, right? But suddenly or eventually, the investment manager or stockbroker requests the customer, this company, to repay the loan, right? To repay the debt. The company was surprised, yeah, because I didn't do any instruction, yeah. But they were aware that their shareholder is doing a lot of instruction under their name or on on their behalf. Yeah. So later on, there was also a letter from the stockbroker to the IDX, yeah, Indonesian Stock Exchange, saying that there was a transfer already from here to there. Yeah. And the company, the customer, because they are being aware that their shareholder was doing something behind their back, they kept silent. But the panel of arbitrators just step into the third point. I remembered that it was related to the release of right. Yeah. So the customer was considered has relinquished or has released his right to claim for that item. Yeah. Objection about the transfer of shareholders. Yeah, because you are not giving any objection at the time when you were aware that your shareholder is doing something behind your back. So it will mean that now, when the legal claim was lodged by this stockbroker, you cannot just deny it by saying that I didn't agree with it. Yeah. So it was not easy, right? It was not easy to see it that way. And of course, the arguments by arbitrators at the time can be seen correct on that perspective, on this release of right. Yeah. But can you imagine that indirectly, because of those arguments by arbitrators, the falsified power of attorney, the falsified action by the shareholders were deemed justified, right? Dianggap benar kan? Padahal tidak pernah ada kuasa dari si customer given to his shareholder. There was no power of attorney given, so it was falsified. It was forged, ya dipalsukan gitu. And the stockbroker was aware of it. But he did it anyway. So in one perspective, maybe you can consider that those arguments about the release of rights correct, yeah. But by relying on this argument, the forging of document, customer are also deemed as justified. Yeah. Well, it's not easy to accept, right? Because it will violate also the appropriate conduct. It's a good faith, violating the good faith principle, and violating the company law, legal provisions actually. Okay, yeah, that is an interesting case actually, but let's move on now. Okay, now we're talking deeply about force majeure. This defense is when the debtor seeks to show that unfulfillment or non-performance of what has been promised was caused by unexpected things. You cannot expect it. And in which he could do nothing about the circumstances or events that arise unexpectedly. You cannot do anything about the pandemic, right? Well, we can do something about it, like taking care of our health, doing the health procedure and protocol, right? Yes, we can, but we cannot avoid totally this pandemic, right? We have to live with it, and we have to adapt with it, right? So this is an event that no one knows. No one can expect it coming. Yeah, maybe they can expect it coming, but no one can control it when it in fact comes, yeah, and hit me. So many businesses suffered because of the pandemic, right? And because of it, people are unsubscribed, perhaps. Yeah, people are stop paying money to you. Yeah, you don't have any money, you don't have any cash flow, so how can you survive? So force majeure, so something unexpectedly, you cannot expect it coming. It's an act of God, right? It can be anything actually. It's not just the pandemic, it can be many things. We will discuss about it. Yeah. It's rare. If you are asking me, will this something that happens often in an agreement? No, it's not very often, of course. Yeah, it is rare. Actually, maybe I experienced the biggest is this pandemic that I experienced when I deal with the agreement. Yeah, when I deal with force majeure clause. But before that, I don't remember. Yeah, I don't think there was any force majeure occurrence. Yeah. Well, maybe there was one or two, but I didn't really remember that. Yeah, so it was rare. Yeah, but it is important. Yeah, because as we experience this pandemic, well, this pandemic is huge. Yeah, it's like covering many sectors. Yeah, but some act of God only covers certain aspects, right? They don't really go like this international wide, all the whole world suffers from it, right? No, sometimes it's just locally, right? So those force majeures locally occurred, of course the impact is different than like this pandemic. So what happens if there is a force majeure? In other words, the default was not due to his negligence or fault. So when there is a force majeure, like I said, people stop paying money because of the pandemic, people are unsubscribed the service because of this, because of that, right? So you cannot pay, perhaps, right? You cannot provide your service to your client as your contractual obligation. You are hindered to perform your obligation because of the force majeure. Now, in a simple way, the law will say, okay, you are breaching the contract. Okay, but you will say, no, I'm not intentionally, right, or negligently fail to perform. Ya, saya bukannya sengaja atau lalai ya, bukan ya. I can't perform because of something that is out of my control, right? Out of my knowledge, out of my control. I can't do anything about it, but I'm suffered also because of it, right? So that's why I cannot do my obligation. So if this is not intentional, this is not my negligence, you cannot claim for cost or expenses, loss, and interest to me. Yeah, that's as simple as that. Because you are not doing any wrong. Yeah, since you are not doing any wrong, the other party cannot claim for compensation. So the debtor should not be punished, yeah, for the non-performance of what has been promised. So this is important. These two are important provisions. You have to look, you have to understand also 1244 and 1245. Yeah. If there is a reason for that, the debtor must be punished to compensate for cost, damages, and interest if he cannot prove that the non-performance or not at the determined time such agreement is performed was caused by an unforeseen event for which he cannot be burdened over it. All of those if there is no bad faith in his side. Yeah, of course, if there is no bad faith, yeah, meaning that maybe you intentionally create or causing the force majeure to happen. And that is the bad faith, right? So you are trying to defend yourself by saying that this is a force majeure, so I'm not doing any wrong, yeah. But you did something bad, yeah. You badly intend from the beginning to use this force majeure as your defense. So it is not unforeseen anymore, but it is foreseeable event, right? Because you created that event for yourself. If there is a reason for that, the debtor must be punished to compensate. Nah, baca ini aja dah, bahasa Indonesia ya. 1244. Jika ada alasan untuk itu, si berutang harus dihukum mengganti biaya, rugi, dan bunga apabila ia tak dapat membuktikan bahwa hal tidak atau tidak pada waktu yang tepat dilaksanakannya perikatan itu disebabkan suatu hal yang tak terduga, pun tak dapat dipertanggungjawabkan padanya kesemuanya itu pun jika itikat buruk tidaklah ada pada pihak. So you are not responsible if there is a force majeure. That's the essence, right? But if you were acting in bad faith, wait a minute, yeah, you are still responsible for it. Well, this is not easy to interpret, but my experience and under theory, that there might be a time that the force majeure was intentionally created by one party. So it was not a force majeure anymore, actually, right? Let's see. Artikel 1245. Tidaklah biaya rugi dan bunga harus digantinya. Yeah, you don't have to pay anything. Apabila lantaran keadaan memaksa, nah this is the keadaan memaksa ya. Keadaan memaksa atau lantaran suatu kejadian tak disengaja. You don't intend it ya. It was unintentional. Ya, it was, you just didn't know it. Tak disengaja si buta berhalangan memberikan atau berbuat sesuatu yang diwajibkan. Atau lantaran hal-hal yang sama telah melakukan perbuatan yang terlarang. So di sini ada keadaan memaksa ya, atau or an unintentional event ya, atau kejadian yang tak disengaja ya, jadi ini agak beda itu sebetulnya. I think the meaning is different ya, between the force majeure or an unintentional event. He is prevented from giving or doing something that is obligated, or due to the same things have done things prohibited. So, yeah, I dealt with a case before. It's a construction contract, yeah. And in the construction contract, there must be a good communication between the project owner and the contractor, because they will talk and communicate about the design, yeah, the project timeline. And then the design will have to be approved by the project owner and everything, right? So sometimes, you know, the project owner is late. It's late very much, yeah, very badly. Let's say that the timeline was for 1 week, for example, for this kind of approval, but then it was delayed from giving or doing something. Yeah, I cannot work because I was prevented. Why I was prevented? Because you have not given your approval. While I cannot work unless you approve my design, right? I submitted my design. You haven't given any approval. I cannot work. But then you said I'm late. Yeah, that was what happens. So we filed a claim, and that's saying that we are on a force majeure because we cannot work, we cannot do unless you approve, but yet you haven't approved, and this creates delay. So these are the things that so when you are asked whether ICC, Indonesian Civil Code, regulates about force majeure, yes, the answer. The ICC regulates about the force majeure. Yeah, not every lawyer understands this. Yeah, I even attended a seminar once about construction contract, actually, about construction law. And one participant asked why the force majeure clause has to be regulated in the construction contract. Is there no law at all regulating about force majeure? And then the lawyer presenting in the seminar said, no, there was not. No, this is wrong. Yeah, there is, and there are two provisions. So we can refer to this, of course. If there is no force majeure clause in your agreement, you can still refer to these two provisions. Yeah, because as the concept of contract law is, the ICC is a complementary, right? It's a supplementing the agreements between the parties. So force majeure, both articles regulate the same thing, namely the release of the debtor from the obligation to compensate for losses because of an event called a force majeure. The circumstances are unexpected, unintentional. So I didn't expect it coming. Yeah, I didn't intend it to happen. Unintentional and unaccountable. So unaccountable meaning that I'm not burdened to it. I'm not responsible for it. And force the debtor to be unable to keep his promise. So force majeure, so something, there is an event that is forcing you to be unable to fulfill your promise, to be unable to keep your promise, to be unable to perform your obligation. So this is the thing about force majeure. Yeah, it can happen many things actually. I experienced a case before also that about a wedding. A wedding in a what do you call it? What do you call it? A wedding place, like wedding hall. Let's say a wedding hall. And suddenly the AC was turned off. The building, the AC in the building, I mean the central AC, was turned off during the wedding reception. Can you imagine that? Wow, that was very bad, right? That was very bad. It should haven't happened to anyone, right? But it happened, and then after that, after the wedding, this marriage guy filed a claim to the wedding organizer, to the owner of the wedding hall, and then the wedding hall defended that it was a force majeure event. Yeah, they didn't expect it coming. It was never happened before. Why? In their defense, they said, because we always maintain this air conditioning, and they provided their evidences. We always maintain it according to a standard. Well, it was something that we didn't know it was happening at that time, yeah, and that's why it was turned off for a few hours. But they said also, but even though it was turned off, we brought emergency AC to supply the air to the wedding hall. Yeah, so that's their defense. So by the expert, you will see when you read the jurisprudences, there is an objective force majeure and there is a subjective force majeure. Yeah, objective force majeure you cannot control it; it's just happened. Subjective force majeure, you have to prove, yeah, when it happens, when the force majeure happens, what have you done to decrease the consequence of the force majeure? Yeah, to reduce the consequences of the force majeure. That's the subjective force majeure. And in the legal case that I gave you, it was an interesting case. I highlighted some of the arguments and some of the testimonies by the expert. Please read them, yeah, because they are important for our understanding about the force majeure. So in the force majeure event, you have to prove the objective force majeure and the subjective force majeure. If you can prove them both, yeah, you are relinquished from your obligation. You are deemed as justified in not doing your obligation under the contract, yeah, because you are prevented to do it. Yeah, you cannot do it. It's not because you don't want to do it. You just cannot do it. Yeah, it's a different thing, right? You cannot do it. Why? because there was a force majeure. So natural circumstances, floods, landslides, earthquakes, yeah, like tsunami, it was a force majeure, right? You cannot control it. Due to emergencies, wars, yeah, war, we don't want to experience it anymore, right? Because we understand the consequence of war. But if that happens, then of course, who can control? Maybe there will be change of government. There will be a coup d'état, right? There will be a coup. There will be change of regulations. If there is a change of government, there will be change of regulations. Yeah. Today I live, tomorrow I die. Who will know, right? Because this is war. Economic circumstances, economic situation changes. Yeah, the pandemic changed the economic situation for sure, right? Yeah. If the state, if a country is suffering a lot from the debt, they might increase this tax, that tax, right? Something that should not be paid, now we have to pay like the 10% VAT. In history now, it is going to be increased to 11% in Indonesia. So it's, wow, it never happened before. Unexpected technical circumstances, reduced function of technical equipment. Well, this is about technicalities, yeah. Maybe, yeah, you just don't know about it. Permanent force majeure and temporary. Okay, there is a permanent, meaning that it won't get well anymore, right? This, for example, is the good or the thing that you have to deliver is just vanished. It's just destroyed, right? Just destroyed, completely destroyed. Maybe because of fire, because of earthquake, anything can happen. So it's a permanent force majeure. I cannot deliver it to you, right? Or temporary force majeure. Well, this pandemic is considered as temporary force majeure. Yeah, it should be temporary, right? We have level 3, level 2, level 1. I hope one day we will have level 0, right? No more pandemic. It should be a temporary force majeure. It cannot be considered as permanent force majeure, yeah, because we are surviving, yeah, and we have to survive the force majeure, right? The full force majeure, half force majeure. This is in terms of the obligation, yeah. How many obligations that you can perform? If all obligations cannot be fulfilled, then it's full force majeure. If it is only partially, yeah, maybe I cannot do that, but I still can do this, right? Or I cannot deliver that, but I still can deliver this. It's a half force majeure. Okay, so absolute and relative force majeure. Yeah, absolute force majeure occurs. This is like similar to the permanent and temporary. Yeah, a force majeure in absolute, yeah, occurs so that the obligation of the contract is impossible. Example: the object that has to be delivered is vanished or destroyed, right? Relative force majeure in which a normal fulfillment of obligation is not possible, but abnormally is still possible. Example: changes of legislation where the government prohibits a certain type of good exported or prohibition on import of a certain type of goods to Indonesia. So you cannot export outside. You cannot import inside, right? But you can perhaps smuggle. You smuggle the goods, right? It happens in every drug dealing, for example, right? Smuggling of drugs. It is prohibited, right? Drugs, export drugs. Import narcotics and everything, but it happens. So that is considered relative force majeure. You might be prevented. Yeah, you are in fact prevented legally speaking, yeah, but non-legally you are actually still able to do it. But of course, the risk will be on you if you are pushing forward, yeah, to do bad things or to do illegal things. In the force majeure, what is the status of the agreement? Now, this is another interesting part, right? Will it still be valid or void? Yeah. If there is an agreement and there is a force majeure event, what happens to the agreement? For absolute force majeure, you cannot do it. You cannot do anything. Yeah. You have to deliver specifically a painting by Leonardo da Vinci, right? About Mona Lisa painting, for example. Mona Lisa painting by Leonardo da Vinci. And then it was destroyed. Yeah, maybe because of fire in the museum or everything. Yeah, well, it's gone. Yeah. How can I deliver my obligation then? I cannot do anything, right? It's an absolute force majeure. So I cannot do it. So it's not logical anymore if the agreement is considered as valid. Well, it's gone. It is like, suatu hal tertentu, right? The third element of validity of a contract is gone. The goods, the definite item that is agreed under the agreement is gone. So it's a objective requirements of an agreement, and it is considered as null and void, right? So it's rational, I think, to consider if it is an absolute force majeure, of course the agreement is void. But what about relative force majeure? If there is one day the pandemic is over, right? Of course, your obligation will have to resume. Your obligations to pay me, for example, okay, let's say that now you're suffering pandemic, you cannot pay this, people are unsubscribing your service, people are stopping paying their money to you, then you don't have money to repay me, right? Okay. But then this is level 1. Is there any better in your business, right? You should have been better now. Okay, and then level 0, or it's gone. You are obliged now, okay? You cannot say just, oh, this is still a force majeure, No. It's going out. The pandemic is over. You have to perform now without reasons, right? Okay. So the force majeure is something preventing you to do something, right? But when the force majeure is gone, of course, you cannot use the force majeure anymore to say that you are prevented. So it's not void in that sense, yeah. The agreement is still valid, and when the force majeure is gone, you have to fulfill. All right, let's continue now. Exceptio non adimpleti contractus. Okay, yeah, it's an interesting name. The concept is good, I think, and it's quite logical, but not easy, yeah, to persuade the judges on with this, yeah. It's a defense that states the debtor does not carry out the agreement as it should because the creditor himself does not carry out the agreement as it should. So both parties are wrong. That's the easy way to say it. Do not consider that I am breaching my obligation if you yourself have already breached your obligation. Yeah. So someone is filing a claim against you, saying that you do this, that, right? But you can counterclaim by saying that I was doing this, violating the contract, yeah, because you did that violation first, or because your violation made me violate the contract. For example, yeah, the easy way is like in a construction contract, for example, when the landlord, the project owner, must approve on a certain date, right? Let's say on the first day every month, he has to approve. But then he just gave the approval on the 5th day, not the first day, right? And the contractor, in the contract, it was stated that if for the project owner must be on the first day, for the contractor must be on the 6th day or 7th day, let's say, on the 7th day. Now the fact is the project owner was late, not granting the approval on the first day, but on the 5th day, right? Now, under the contract, contractor must perform on the 7th day. So before it was 6 days apart, from the first day to the 7th day, 6 days apart, right? But now from the 5th day to 7th day is only 2 days apart. So they cannot do it. They can do it on the 9th day, for example. So 5 to 9, 5th to the 9th day is 4 days. So under the contract, you have to perform 7th. But in fact, you perform it on 9th day. So you violate the contract, right? It's easy, right, to see it. But the contractor will say, okay, I'm violating the contract, but you violated the contract first. In fact, I violated the contract because you do the first violation. So this is the exception on adimpleti contractus. Yeah. And of course, this kind of defense only applies to reciprocal agreements. Yeah. Reciprocal means timbal balik. Perjanjian timbal balik bukan perjanjian sepihak kayak hibah. Ya. Kalau hibah kan ya apanya timbal balik. Tapi kalau semua perjanjian hampir timbal balik ya, only hibah perhaps dari sepihak. So this can only apply to reciprocal agreements. So there is no general provisions regarding this exception in the ICC. Yeah, there is none actually. This principle, but one you can see in here, the principle in sale and purchase regulated under Article 478. The seller is not obligated to deliver the goods if the buyer has not paid the purchase price. Yeah, I'm not obligated to deliver as long as you have not paid the purchase price. Whereas the seller has not granted him an extension of the period for payment. So if you are late, if you haven't paid the purchase price on a certain agreed date, right? I'm not obliged to deliver the goods. So this is not really an exact non-adimpleti contractus actually, yeah. But it is, you can see that it is in the essence, yeah, of it, yeah. So I'm not obliged to deliver because why? Do you know why I'm not delivering you the goods? Because you haven't paid me. Okay, so you pay me first, and then I will deliver the goods. Yeah, right. So you can see it that way. Okay, this is a Supreme Court decision. It is very old, 1955. But there is a more modern legal consideration. The party required by the opposing party to fulfill the obligation according to the agreement can defend itself with the proposition that the opposite party itself does not fulfill its obligation according to agreement, so that he is free from his obligation of agreement. Well, it's not as easy as that, right? And the obligation in an agreement, if it is one obligation, just like the sale and purchase 1478 that we, but sometimes the obligations in this, and then you do that afterwards, yeah, or you have to do both two obligations altogether, right? Well, it's not as easy as that, right? This is just a principle, legal rule taught as a principle. So, but of course, the application in a legal case might differ, yeah, because in a dispute, in an agreement, sometimes it's not as simple as that. Okay, now we are moving to the third item, Rechtsverwerking. Yeah. Okay, Rechtsverwerking. This is the relinquishment of right, yeah, release of right. Debtors, in their effort to deny the existence of the state of default often take issue whether the creditor still has the right to claim or not. So the Rechtsverwerking here is related to whether you are still having the right to claim or not. Yeah. So if you are considered as relinquishing or as releasing your right, you cannot claim anymore, right? Because the right to claim is released already. So if it is considered as released, you cannot claim anymore. So example, a buyer does not complain to the seller or return the goods, but use that goods, even though he is aware that he purchased goods, that the purchased goods is not confirming to the quality that he is intending to have. Jadi dia beli barang, ya kan? Dia tahu nih barangnya nggak benar sebetulnya, nggak sesuai dengan apa yang dia minta. Tapi dia tutup mulut, dia nggak komplain, dia nggak ajukan keberatan, dia pakai malah, but use that goods, ya. So this can be considered as you are fine with it. You are fine with it. And if you are fine with it, no complaint, right? No complaint, you are fine with it. Why suddenly you claim? Yeah, it doesn't make any sense. Yeah. Or even now, this is even stronger proof. Yeah. After the first order, he reorders the same goods. So he is aware already that it's below his quality, the expected quality that he wants. But then he reorders. From that attitude, yeah. So, well, law, you cannot detach attitude at all, yeah. Because this will apply like if the agreement is not extended, let's say that the agreement was valid for 2 years and then should be extended for another 1 year, but the parties forgot to extend, the questions that will arise that will this previous agreement, the 2 years agreement, are still valid or not. Why? Because the parties are still doing the transaction until now, even though there is no underlying agreement. There is no agreement. Or there was an agreement, but the agreement was not extended yet. So there was not agreement now, right? But the attitude of the parties show that they are acting in good faith, right? They are paying the money. They are delivering the thing that was ordered for the past 1 year. So it doesn't seem that there was no extension, right? There was an extension actually, even though it was not made in writing. From how do we interpret that? Yeah, from their attitude. Because if they don't want to extend the agreement, of course they will stop doing any transaction. But the fact is that they are still keep on doing the transactions. So in this regard, it is similar. From that attitude, yeah, by reordering the goods and you use the goods again, it can be concluded that the goods is satisfactory. If he then later claims for compensation, that right to claim is considered to be released already. It's hard to justify your claim if you just can you just use the goods, right? You reorder the goods, well, but then so this is important, I think, yeah. And it's interesting also. It's an interesting concept. That's why, you know why this can be interpreted, right? If your attitude is like this, then one can interpret that this happens, the relinquishment of right happens. So that's why in the contract, normally you will see that no waiver will be given or will be considered as having been given if unless it is made in writing. Yeah. So the parties don't want that because of the attitude, yeah, because of the attitude, it will seem that there is a waiver. No. Wait. The waiver is only with writing. If it is not in writing, there is no waiver at all, right? But even though you have that kind of clause, that doesn't mean that you will have a strong case. I think, yeah. If you remember correctly, what I mentioned in the morning, just when we started about the case between the stockbroker and the customer, right? There was no waiver in writing, right? And there must be a power of attorney, right? But it was not there, power of attorney. So what I'm trying to say is, even though you have that kind of clause, yeah, still the attitude is considered important. Yeah. Even though you have a case, even though you have a clause that it has to be in writing, but if your attitude show that you don't care, yeah, you don't complain, you keep your mouth shut, yeah, you are fine with it, you are look or seemed fine with it, right? You will be still considered as waiving your right, in my view, yeah. In the case that I experienced, that was the view of the arbitrators, yeah, because they would like to see that you should have complained when it did happen, not just in the legal claim, yeah. Well, yes, in the legal claim, you complained. Yeah. We know it. We know it and we understand it. But why you just keep your mouth shut when it did happen to you? Now, so I think that position is, can be justified, yeah, arguably justified, I think, even though it also justifies the other violation of the law. But well, there's no perfect case, I think. This depends on whether the buyer has passed the appropriate time to protest the delivery of bad goods or not. Past appropriate time measured from since the deficiency was known. In the event that the deficiency in the seller's obligation is a defect that does not appear, then the buyer must be given a longer tolerance of time to protest than if the defect appears. Yeah, this is talking about hidden defect. Yeah, hidden defect you cannot know, right? But when it is found out, you can have a claim, yeah, based on the hidden defect, but it was not for long. You have to bring the claim in a short time.